Defense can ask questions from Dr. P.W. about medico-legal examination of accused persons. Procedure explained in the light of provisions under Articles 152, 155, 156 of Qanun-e-Shahadat Order, 1984 read with Section 265 F7 of CRPC, prevailing principles governing cross-examination, its scope in law and limitation. There are 4 broad objectives, so each cross-examination must have at least one of these as its aim. They are: A. Laying the foundation. B. Putting your case. C. Eliciting extra and useful facts. D. Discrediting the evidence. The aim of cross-examination is to advance the case of accused and to undermine the case of prosecution. In order to achieve this aim, it is the cardinal rule that while cross-examining the witness on a fact, defense must put his case there and then, in the form of questions about related facts in the knowledge of defense, though concealed by the prosecution or not part of examination in chief. Otherwise, it would be regarded as later invention to label it as concocted or afterthought. Undermining the prosecution case means limiting the testimony and discrediting it, whereas advancing the case of defense means eliciting favorable testimony and developing the case of defense. These 2 principles find their place in Articles 139, 140, 141, 151, 152 of Qanun-e-Shahadat Order, 1984. Article 139, 140, 141, and 151 deal with discrediting the prosecution case, whereas Article 152, a deviation to general rule, relates to advancing the case of defense. Although the import of article proves in favor of granting such permission while conducting examination in chief, but there is no explicit bar to permit such explanatory questions in cross-examination. Corroboration, in order to be of any value, must be on material particulars and the facts relied on, for corroboration must be established by reliable and independent evidence. These facts must be such as to lend assurance to the crucial issue which is in question. In the light of above referred provision and case laws, defense counsel must have been allowed to ask such questions from the medical officer during the cross-examination, and defense counsel can refer MLC's and radiologist report for asking question while showing it to the witness for the purpose of refreshing the memory, as mentioned in Article 155 of Qanun-e-Shahadat Order, 1984. And such witness can also be testified for the facts mentioned in such MLC's and radiologist report, whereas prosecution has also right to cross-examine such witness to this aspect while seeking permission from the court pursuant to Article 150 of Qanun-e-Shahadat Order, 1984. However, during cross-examination, such documents can simply be referred and could only be tendered in evidence at a stage mentioned in Section 265(7), KRPC. Thus, as per Article 155(1), medical officer can see the MLCs, and, as per Article 155(2), also the radiologist report in the same fashion to refresh his memory for responding to the questions put by the defense. After refreshing the memory, medical officer can be testified for relevant facts connected with the circumstances, including date, time, and place of such medico-legal examination. Clocker Revision Against Interim Orders, 206 Muhammad, Aslam versus State T.